Hello, and thank you for joining us on the Ask Andrew show today, Canada's first Facebook Live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal and founder of Feldstein Family Law Group, a law firm dedicated to serving our clients' needs in all areas of family law. We practice in Markham, Vaughan, Oakville, and Mississauga. Today, I'm being joined by one of our very talented associates, Lauren Harvey. Welcome to the show, Lauren.
Thank you, Andrew. I'm happy to be here.
Well, we're glad to have you. Today, we're going to talk about something that often surprises people, and it may sound like a boring topic, but it's court costs. And court costs can sometimes be a really important issue in the litigation because as the case drags on, the court costs may become more significant and even an impediment to resolution. So can you explain a little bit about the system and how we have a loser pay principle for costs?
Sure. So in family law proceedings, costs refer to the legal expenses that parties incur, and those can include lawyers' fees, court fees, and other expenses related to the litigation. When we're looking at what legislation governs kind of the cost principle, we're looking at Rule 24 of the family law rules, which states that successful parties are presumed to be entitled to costs of a step in a case. Their costs are usually awarded to sanction behavior that increases the duration and expense of the litigation, or is otherwise deemed to be unreasonable or vexatious. They're also meant to try to get parties to encourage settlement and are designed to ensure cases are dealt with justly. So we often see costs awarded in cases where, a motion is brought that never should have had to have been brought because the issue was so clear or so straightforward that it really should not have resulted. It shouldn't have needed a motion. And the goal of costs in those circumstances are, one, to compensate the party who had to incur expense to bring a motion, but also to kind of demonstrate to the other party consequences of what can happen if this behavior continues, the unreasonable behavior.
Well, when you think of the unreasonable behavior and you think of court cost, that's part of it, but it's not always unreasonable behavior. Loser pay can be very challenging, and sometimes there can even be an argument as to who was the loser and who was the winner.
Yeah.
So
it's discretionary completely.
So
and I think,
go ahead.
I was just gonna say, I think, Andrew, that's one thing that I have been finding myself having to explain to clients on more than one occasion is, yes, there are costs, but it's not an all or nothing. And it's kind of rests a little bit in the judge's hands. And obviously there's things that you can do to better your claim for costs, right? Behaving reasonably, preparing an offer to settle, bringing motions that actually have substance, that there's a likelihood of success. So there's things that you could do to protect yourself, but costs are discretionary in the court's hands. And it's quite possible that even if there's a clear winner of a motion, a judge may say everybody bear their own costs.
So let's start by walking it back a bit.
Yeah.
And that when a court application is commenced, claim costs. When you do the answer and make your own claim, you claim costs. And then the rules, as you mentioned before, allow you to make an offer to settle. And the places where judges are going to make orders for costs are when you go to court, when you make an appearance. And there are three typical appearances in a family law proceeding. There's a conference, there's a motion, and there's a trial. And I say them in the order of when they happen, because conferences usually happen first, but I also say it in the order of least expensive to most expensive. A trial is really expensive, and there's a rule on offers to settle that apply to trials, which is in order for it to attract cost consequences, the offer needs to be made 7 days before the commencement of the trial. And a motion is 24 hours before. So do you want to explain some of the things that go into the offer to settle for our viewers and why that's significant and why it's important?
Yeah. So it depends, obviously, the issue of the motion or of the trial. But you always want to have a kind of a definition section outlining, if there's kids, who is what party, so that there's no real dispute later about the terms of it. You're also going to want to, depending on kind of where you're at in the litigation and how the file's going, you're going to want some sort of a term about cost consequences, right? So sometimes what we see, Andrew, is if this offer to settle is accepted by X date, everybody bears their own cost for the motion. But if it's accepted after that date, the party who accepted it after the deadline may pay partial costs up to the date of the offer to settle and then full costs thereafter. You can structure it in different ways. There can also be just a term of partial costs up to the date of the offer to settle and full indemnity after.
Yeah.
Another
the important thing to note is that the rules say that if you make the offer to settle, you're entitled to partial recovery of, or you're entitled to cost to the date of the offer to settle and full recovery of costs from the date of the offer to settle forward. So it's really, really critical to be making those offers.
The other thing to canvass is sometimes you have a motion, or certainly when you're at a trial, you may have multiple issues, right? So there's been times, Andrew, that you and I have said, let's make this a severable offer, right? Which means somebody can accept certain parts of it. Maybe there's certain parenting terms and then equalization or some sort of financial terms. And you can make the parts severable. Sometimes when those parts interplay with each other, it's difficult to make it severable. For example, parenting and child support, they kind of a little bit flow from each other. But, you can make the parenting term severable from the equalization. And the goal there is you don't have to resolve everything at the same time, right? If you can resolve one issue and at least call that resolved, and then you can focus on kind of the other issue that's still in dispute, that can be a helpful way to also try to attract a more favorable cost award, is if you gave the person the option to accept some of the offer to settle without accepting the entirety of it. Though sometimes that may just not be, like oftentimes in a motion, the issue is a lot more narrow, that there's really just one or two things that are the issue of the motion. And so it's kind of difficult to make a separable one. But we see those a little bit more often when you're doing a comprehensive offer that deals with maybe all issues in dispute in the matter. But it's a strategy.
And the reason why it's an effective strategy is because of the loser pays concept. Because if you take the motion as an example, where there's two items on the motion, and you've made an offer to settle that is severable between the two, you may win on one and lose on the other. And that may mean that you've done better and you're going to get a little bit of cost if they didn't have an offer. That becomes really important, because if you didn't have that offer to settle, you may your client may end up paying all of the costs I shouldn't say all of the costs, because if you don't fall within the rule dealing with offers to settle, then the judge has the discretion to make an award for costs. And that discretion would be on a partial indemnity scale, not a substantial or full indemnity scale. So you're also protecting your client from being in the position of paying costs. And that also governs as a way to make you a little bit more reasonable and honest as you get closer to court, because you want to analyze your offer to settle from the perspective of, can my client live with it? And do I think I can beat it? Because those are really the two aspects that go into it. And if the answer to those two questions are yes, you're really putting pressure on the other side and hopefully trying to resolve issues, because that's better for the clients. But it's a bit of a chess game for costs, and clients need to understand trials costs can be well into six figures. Motions can be a lot of money too. So these are really, really important issues that you can't be dismissive of.
And the other thing to keep in mind, I probably should have said at the beginning, Andrew, is offers to settle are without prejudice, which means that if we have a motion happening this week on Friday and we serve an offer to settle today, which is Wednesday, so still within the 24-hour rule, and this motion goes ahead, they don't accept the offer to settle, the other party's not allowed to comment on the substance of that offer to settle, or even that one was made in front of the motions judge before that judge has made a decision and is just considering cost. So you don't have to worry about, or at any stage really, if you've made an offer to settle, it's without prejudice, and it can't be put before the court other than in a conference, which are without prejudice by nature. But at a trial and a motion, it can't be referred to later prejudice your position. And the point of that is parties should be allowed to, express that they may make certain concessions on some issues and maybe take different positions than what they took in the litigation, with the goal of settling without that being used against them at a later point.
And, what you're saying is really good piece of advice for our viewers, but I'll add this. Even if you don't beat your offer to settle, one of the factors judges look at on motions or trials and costs is, did you make an offer? Did you make more than one offer? And even if you make an offer 36 hours before the motion and the other side makes a counteroffer 24 hours before the motion, it doesn't mean stop making offers.
Right.
Because even if it doesn't attract the cost consequences on the rule, it still
Goes back
attracts
to that,
costs.
and it still goes back to that reasonableness element that judges will often consider in determining whether they're going to award costs, and if so, what the quantum is.
Exactly. So it's something I would really urge people to be doing in the family law context, whether you're counsel, another firm watching this, or whether you're a self-represented or even one of our own clients. It's a good thing to do when you're in a place to do it. And what I mean by that is when a client walks in the door with an application and their former spouse is self-employed, and I say to them, what does your spouse have? I don't know. What's your spouse's income? I don't know.
Yeah.
And it may sound shocking to some people, but a lot of people, they go into a marriage, they trust their spouse. There's always money, there's always able to use the credit card. There's always things are paid for. The car is paid for. They never really had to worry. And then they walk into a lawyer's office like ours and they don't know. Well, we can't make an offer to settle because we don't know if they make 100,000 or 10 million in a year. And those are the kinds of things we have to do work. But as the information starts coming in, and at a certain point, we're in a place where we can turn to our clients, say, okay, we think we have a handle, at least on a range, that we can start talking settlement discussions. And one way to do that is an offer to settle. And earlier you make the offer, it looks better for the ultimate matter, in the sense that if you're in a position to make an offer and you made one and they don't accept it, great. And in fact, you can make multiple offers to settle without having to withdraw the offer. So if on Monday I make an offer that says, pay my client $5 million, on Tuesday, I can make an offer for them to pay my client $4 million. The nice thing is, I don't have to withdraw the one at 5 million because, well, if they want to accept 5 million, I would certainly take it over 4 million. But if I go to trial and I get 5 million, then I started the clock on Monday and not Tuesday because I beat the Monday offer. So typically, it even makes sense to keep old offers open if you were asking for more than newer offers, because why do you need to start the clock over on that particular offer? So there's some complexities to it, there's some nuances to it, but all of these points can seem a little technical to our viewers, but the basic concept is make offers, try to work things out. Don't take on that position of, well, we'll go to the judge. You know, I was somewhere earlier this week and I was sitting and I was overhearing a conversation because one gentleman was really loud and he was saying to the other gentleman, well, what she did was wrong. I want a judge to tell her that she was wrong. I don't care. I'm going to court and I want a judge. Little does he know he has a 30+ year divorce lawyer hearing him have this discussion and thinking in my own mind how little he realizes or appreciates, because there's a huge cost to get in front of that judge and there's a huge risk, because if you're unsuccessful, that judge that you think is going to vindicate your position may not. You may be paying for their lawyer. So I say that to people because if that gentleman was there and the gentleman thought he knew what he's entitled to and it was realistic, then make an offer to settle early. Protect yourself from costs and set yourself up to recover costs. So, you know, that's sort of, I'm going to take to another question that we've somewhat discussed, which is who and when. Who's allowed to ask for costs in a family law case, and at what stage of the proceedings can they do that?
So either party, an applicant or respondent, can seek costs pretty much at any stage in a proceeding. So like you said, after a motion, after a trial, or sometimes even after a conference. I would say probably a little bit less likely at a conference, though some circumstances where a court may order costs at a conference is if a party hasn't provided disclosure such that really the conference is not productive, because the judge can't really, the purpose of a case conference is for both parties to present their theory of the case and for the judge to be able to, after hearing that, kind of give them an opinion, but also kind of sway them towards a potential settlement. And if parties show up to a case conference with substantial disclosure outstanding, the judge is kind of left with their hands tied, right? How much of an opinion can they really give? And what that results in is that it wasn't a productive case conference. And I've had judges before say, or I've seen endorsements that say case conference not held. because we weren't able to because there wasn't enough of a disclosure. So sometimes in those circumstances, you may get a judge that said, sorry, go ahead, Andrew.
No, I just want to say our viewers need to understand a case conference under the rules is the first event that really happens in your case. And in some courts, it takes 4 to 6 months to get a case conference date. And until you have the case conference date, you don't get to ask a judge to say, I want the child to live at my house, or children. I want my former spouse out of the house. I want spousal and or child support, among anything else, because the rules say case conference first unless it's urgent. So the danger and the fire you're playing with in Lauren's example, when the judge said case conference not held, is if you want support, you can't bring a motion, and it may be 4 to 6 months
before you can even get a case conference, at which point then you're going to be looking at booking a motion date, which is probably several months after that. But it's possible at a conference. I think it also depends on the circumstances of the case, though, too. But I've certainly
the reality at a case conference, it's about a party who's attending court, and the rules refer to absent or unprepared party.
Yeah.
So if somebody doesn't show up, sure, you're going to get costs. That's easy. But unprepared is the one that Lauren's really talking about. Unprepared is not filing materials. Unprepared is not doing the disclosure. And it doesn't necessarily mean have to be perfect disclosure. You may be working on a business valuation and it's not ready yet. Okay, the court understands that. But you certainly should have had your income tax returns, the backup of your bank statements and credit card statements, things that are in your control, you should have done to be ready to move the case forward.
And what I'm seeing more and more, Andrew, I know in a couple of my cases, is at the case conference. I mean, I obviously haven't been doing this as long as you have, but I think in the beginning, it was, you could go to a case conference with a request for information for the disclosure you wanted from the other side, or that you agree to exchange it within a certain amount of time. I think judges are really putting the pressure on a little bit to get people to actually agree to certain disclosure orders during those case conferences, because it pushes the matter forward, right? It forces it to move forward rather than setting another deadline in the future. So I think they're trying to be a lot more productive with the case conferences.
I couldn't agree more. I remember years ago, it would be you go to the case conference and you are really having your first discussion with the other side at the case conference. And the judiciary has made it very clear to us that's not the way it's supposed to be. We should be working on disclosure in advance of the first case conference. We should be having discussions. We should be considering mediation. We should be doing work to get ready for the first case conference. Now, that being said, it takes two sides to work together. You don't always have two sides to work together. And being a lawyer is almost, I hate to equate it to this, but it's almost like two kids who get in trouble, and there's the parent who's going to decide who's right or wrong. And what we're trying to do is say to the judge who's like the parent, look, we gave our disclosure because we knew what they wanted. They didn't even make a request for it. And we've made a request for the disclosure from them, and they haven't given us anything. And you watch, the judge will be incredibly frustrated with the other side. You may or may not get costs, because judges don't seem to like to give costs at a case conference. But if the answers that they're getting are more foolish and more foolish, to be polite, from the other side, and frustrating to a judge, the more likely they are to order costs. But at a conference, how often do I see getting costs at a conference where I've got them? Once every few years.
Yeah.
Whereas at a motion, it's almost every time a judge will get an order for costs, like you did recently. You were very excited. You got almost full recovery of costs on the matter.
I did.
And at a trial, costs are going to flow every time. So I say that as the backdrop of what Lauren is saying is you ask for costs at every court appearance at the conclusion of it, but you only ask if you think you're going to win. And sometimes it can even be a bit strategic, because it used to be we would hold on to our bill of costs until a bill of costs is where we prepare how much we charge for the motion or the trial. And when we would go to motions, we used to never give our bill of costs in advance. I don't know if you remember that, Lauren. We used to keep them. And if we won, we put our bill of costs forward. And if we lost, we didn't. And the strategy behind that's really simple. If my bill of costs is more than the other person's, and I jumped in and said, look, my bill of costs is $10,000 and theirs is $5,000, then that guy's going to hold back his 5 and say, look, I'll take the 10. I mean, I remember I did that once. Somebody served me on 2 days' notice. I barely got my materials together. I didn't have time to do the bill of costs. The other guy was so cocky, he handed me his bill of costs, which was twice of what my time was. I went in, I slaughtered the guy on the motion. The judge says, what about costs, Mr. Feldstein? I said, well, Your Honor, I didn't have time to do one, so I'm happy to go with my friend's bill of costs. And I got his costs. Great. It was a good day for that client. But I say that because the rule is now changed, where they want us to exchange our bill of costs in advance.
And even if you have, I've at the motion, maybe not this last one, but a recent one that I did, judges are wanting you to have a discussion about agreement on what the cost payment will be to the successful party in advance of the motion even being heard.
Exactly. And that's something they adopted that the Court of Appeal would regularly do. And the fascinating part about that is it's really a glimpse into which lawyer feels more confident about the case. Because if you really feel confident about your case, you're pushing for a bigger number on costs. I remember I once argued an appeal years ago, and I wanted the bigger number, and the other guy's like, oh, come on, Andrew, let's put a lower number down. Let's don't have it. And I laughed and I said, boy, you're feeling very confident in your case today, which he agreed to, and we reached a compromise. But there's something telling in that. Now, that doesn't affect what the judge is going to do or not do, but it's certainly a sign of confidence in where two sides are at. And sometimes you may be shocked at what the other. I remember one time I had a motion where my costs were 25 or 26,000 and the other side was over 80,000. You know, that blew my mind away, the 80,000. So I say all of this because costs are out there. And one of the biggest problems clients don't appreciate is we do a ton of work on the merits. And then the judge asks us for the costs, and we hand the judge a bill of costs, and we may get 3 minutes of a submission to give in court, and the judge is going to make a ruling on, in that case, a swing of $110,000. So it's important to be aware that there can be a lot at stake in these bill of costs, a lot at stake by virtue of the offer to settle, a lot at stake as to who won or lost, and trying to position for that kind of contextual play in terms of making sure, should my offer be severable? I mean, I'll give an easy example. Something I changed up about a year or two ago is we hate bringing disclosure motions. I'm sure you'd agree with that, Lauren, because it's tedious, but we do them. And we used to make an offer to settle that would say something like, give us all the disclosure and consent to give us all the disclosure in 30 days. And the list could be 30 items. We may get 27 of 30, and the other side would say, well, Mr. Feldstein wasn't successful. He only got 27 of 30, so at best he's entitled to costs. Okay, judge may or may not agree with that. Now we make that offer severable, where they can accept to provide us with any of the 30 and
we argue about the rest. Yeah.
So now if I get 27 of 30 and they didn't accept it, well, Your Honor, they should have accepted the 27, and this long motion would have only been for 3 items. And if it's only for 3 items, clearly I should get full recovery of costs. If you want to just do it as a ratio on 90% and partial on 10%. So you really need to think about how you break your offer down. Lauren also talked about how sometimes things are linked. So sometimes you break them down by making parts, and you put the things that are linked in one part.
Yeah, that's what I was saying. Like parenting, part. Child supports. I usually do like parenting and support. You could do equalization separately. You could do matrimonial home separately, but just bearing in mind that there are certain issues that might be distinct issues in family law, but actually will, if I have one proposal that is, for shared parenting, but then my child support section is not a set off amount, right? Which is what happens if there's shared parenting. It logically doesn't really flow and make sense. So just there's a lot of strategic drafting that has to go into them, and you need to be very, very careful when drafting them, because if that offer to settle is accepted, there's been offer acceptance, and that's the order that's going to be entered.
And what people also need to understand, when you do an offer and the other side writes, I accept, don't think for 1 minute that means, well, there's no agreement signed yet, it's not a deal. Wrong.
It is.
It's a binding deal, and somebody can go to court, and I've done it many times, and bring a motion to have that deal turned into a court order.
And that's
So,
what we always include. I always include a term in mine, and I know, Andrew, you do too, that, if this offer to settle is accepted, it will be turned into either a consent order or a separation agreement to be drafted by this party, right? So that there's no dispute about what the intention of the parties is upon acceptance of this offer to settle.
so don't think you can be cute and accept or not accept or play games that way, because some people will think until it's done, it's not done.
And that's
Wrong.
a perfect situation where you will get a cost order probably slapped against you.
Yeah, that's probably a good bet. So here's my next question. How can a family law lawyer help?
Yeah, so having a lawyer, I mean, in general, going through a family law process, it's emotional, it's taxing. You're going through a lot of times the most difficult part of your life, but especially with an offer to settle, which is such a technical document that really, like you said, there's a whole rule in the family law rules about what has to be done on what timeline, what the language has to be like in order for that offer to settle to be able to attract cost consequences, right? So it's not enough to just say, an offer to settle one page, this is what I want in one sentence, right? That may not be sufficient to get the cost that you want. So a good family lawyer will help you craft strong, strategic offers to settle, which is really key to protect from costs. Okay?
And our viewers need to understand too, sometimes what may go into an offer to settle that is really aimed at resolution is different than an offer to settle that is aimed at a court appearance and either a motion or trial. What I mean by that is, if I'm doing an offer to settle that I want a resolution, I may put in a provision that will include releases of spousal support or releases of property. A court doesn't have the jurisdiction to do that, which then means if I include that in my offer to settle, it may not attract cost consequences because I've asked for something in my offer I can never get from a judge. So that's an offer that's based on trying to resolve the matter, but I may have to go back and do a different offer
if you
that
get close to trial.
yeah, that is
Or
going,
motion, yeah.
or even at the same time, that doesn't necessarily reflect releases, but may reflect a dismissal, which is similar to a release. But the point of what I guess I'm saying at the end is gets back to what Lauren says. These are highly, highly technical things with a lot of minutia to them, and it's not always overly simple, like some people may think. Well, let's do an offer, because if you do an ambiguous offer, that's where you may get into trouble, because you may end up with a fight about what it means. Was there really the meeting of the minds versus it being properly done? And in fact, one of the things when drafting an offer I try to think of is, if it's a well-drafted offer, you should almost be able to go onto your Word document, change it from offer to settle to minutes of settlement, and just amend the language slightly to reflect the language of minutes of settlement. And what I'm saying there is, this document is really your boilerplate or your template that you're going to use for drafting the minutes of settlement.
Yeah. The other comment, just Andrew, before I know we got to get going, lawyers also understand what judges think about costs, okay? Because we've been before them and we know where they tend to sway sometimes on this issue. So we can really help you assess which issues are worth fighting over and which battles to let go of. That strategy can really save you thousands in the long run, not just in fees, but also in avoiding a big cost order from the other side if they're successful.
Well, one of the themes that I've often said to people on the show is, just because a rule or a statute says something, the word that's usually there is may. And when you don't do family law every day, you interpret may as to think, well, I can marshal the logical reasons that a judge is going to make that kind of order. And we can sit here as lawyers who do this every day in the trenches and say, you know what? I know a judge says may, but I may see an order like that once every 5 or 6 years. And there's usually a very good, highly unusual set of facts that will lead you down that road. And that's meant for that critical case where somebody has disappeared, you can't find them, and the court has to take tremendous efforts to make sure that the children and the former spouse are in a decent place. But absent that kind of unique circumstance, the court's almost never going to exercise their discretion on the may like a lay person will believe. And that's one of the things you pay for us, is to tell you where your case is weak.
Yeah.
And when we tell that to you, we're telling that to you as the person who stands to send you a bill for our work, but we don't want to send you a bill for a work that we don't believe in. And we'll tell you that.
Yeah.
So, Lauren, I believe we are out of time now. So I hope our viewers have gotten an idea about costs and we haven't made it overly technical or overly complicated. And we're here to help you, and we're here to help you navigate your way through the process. And if you're looking for any assistance in separation or divorce, feel free to reach out to us and contact us. You can see us on our website at separation.ca. The next Ask Andrew show will be on Tuesday, May 27th at 12 noon. And if you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.